further ado, over to you.
Yes, thank you, Glenn, for that introduction. I am Scott Duke. I'm a lawyer with the Department of Justice Canada here in the Northern Regional Office in Yellowknife. I will insert the standard disclaimer at this point that this presentation and any of the views I express herein are my own and not those of the Department of Justice or Government of Canada. Thank you very much for coming. I hope everyone's well and keeping healthy during these times. I am always pleasantly surprised and very flattered when as many people come out to these things as they do. So thank you for that. Before, when we were still having technical difficulties, I was squinting at some of the faces on the screen, and I see a lot of familiar ones there. So hello. For those of you who used to be up here and have long since moved away. My hope today with this presentation is to give you, as the title suggests, some sense of the evolution of law and legal institutions in the Northwest Territories. I think that when many of us start practicing up here for the first time, we either don't think about how these things develop or why the way they are, or we just assume that they are the way they are because it's the same as in Southern Canada. I think certainly that was my initial impression when I came up here. As we all know, or as I think anyone who's practiced up here know, that's definitely not the case. And if there's anything like a theme or a thesis to this presentation, it could be, like so many things about the North, that, quote unquote, it's different up here. And it is different up here. And there are very good historical reasons for that. Another theme, I think, that will become obvious, maybe a corollary of the first, is that, you know, when I call this, or when I talk about the evolution of law and legal institutions up here, that sounds like it's this very organic, sort of step-by-step deliberative process. As we'll see, it was definitely not that. One of our previous prime ministers once said that Canada has governed her Northern Territories with an absence of mind. And I think that that is very true of the law and legal institutions in the Northwest Territories. It's definitely been reactive, not proactive. I'm going to cover about 350 years of history in less than an hour. I've got speaking notes that I'm using for this presentation. I did make those available to the Law Society. If anybody wants a copy of those, they can contact Bob or Glenn or I, and I'll be happy to give you one. I do want to leave some time for questions or discussion in case there is any. So let's go. Before we get into the actual, the quote unquote law and legal institutions, I'll just say a few words about the before times, if I may, pre-contact, pre-European contact. There certainly was nothing like Anglo-Canadian law or legal institutions as we know it now. The Indigenous peoples of this area had traditional forms of governance, traditional forms of dispute resolution, and those were left largely untouched even after first contact and the Hudson's Bay Company's arrival. The first era, I guess, if you will, where we first see the evolution of what is what we would know as law, at least Anglo-Canadian common law and statute law, and something that looks like legal institutions, is the Hbc era. I think everybody knows HBC. When I use that, I'm going to refer to the Hudson's Bay Company. But as an old Inuit guy told me in Pangnirtung years ago when we were looking at the old HBC post there, and he asked me, you know what HBC stands for? And I said, sure, Hudson's Bay Company. And he shook his head and he goes, here before Christ, Sonny, here before Christ. They weren't here before Christ, but they did get a charter from the English Crown in 1670, gave the company exclusive rights of trade in Rupert's Land. Now, Rupert's Land, that's very loosely defined. It's basically the watershed of the Hudson's Bay, as we would know it today. It did not, at the time, include what we would call the Northwest Territories. Not even historically what had been part of the Northwest Territories. The HBC charter gave the company the privilege of exclusive trade, and it also brought with it an exclusive right of judicature. The HBC had the right to basically create legal institutions and administer law within its territories, more or less as it saw fit. One of the only constraints on that is that they had to be, quote, reasonable and not repugnant or contrary, but as near as may be agreeable to the laws, statutes, customs of this our realm. In other words, whatever the Hudson's Bay Company did in Rupert's Land had to be consistent with English common and statute law. It was known then. So that's the HBC. On the other hand, you've got the imperial government, the crown, king and parliament, as it then was in Britain. So the law that the HBC is applying in its territories, if and when they did, was English common and statute law. Over the next 50 or so years, that imperial government passes a number of statutes to clarify its jurisdiction, to clarify where and how that law is administered. I won't get into the details. There are a lot of questions about that. But they eventually do settle it. And really the only important point to note here is that the decision is made that the reception date for law in these new territories is going to be the law in England as of 1670. That creates problems. It creates problems almost immediately, and those problems simply get worse over the years. So that's the law, but the Hudson's Bay Company doesn't really have much by way of what we would consider to be legal institutions. In the early years, it's pretty much left up to the governors of individual posts, the factors of individual posts. The law, quote unquote, is really only invoked if there is a dispute involving the company or a dispute between two employees or officers of the company. Disputes between HBC men and Indigenous people are more or less left to be settled by themselves. The company doesn't really insert itself into that. And quite frankly, they've got little inclination about using the law or enforcing or applying it, except as it occasionally applies to rival fur companies. The problem, of course, is if you don't have courts and you don't have judicial officials and you don't have sheriffs, anything like that, what do you do if you find someone who's murdered a Hudson's Bay Company employee or stolen from one of their forts? Well, basically you have to clap them in irons and transport them all the way to Montreal, which in those days is a problem. So the HBC is basically disinclined to do very much with its jurisdiction or create any courts or institutions to implement that jurisdiction. By 1835, they create this general quarterly court. It kind of looks like a court, but it's not really a court. They've got company officials with some judicial training providing over it, but they're not called a judge. They don't have tenure. Not surprisingly, this coincides with the settlement and the expansion of the Red River colony. There's a bit more of a need now for some machinery of law and some administration of justice to settle disputes and other issues associated with this growing colony. But they're not courts. And when they do apply the law, they're still applying English law as of 1670. And this just gets increasingly problematic. But this all changes in 1870. And the biggest reason it changes is because Canada, as it then was, acquires Rupert's Land in the Northwest Territories. This is the beginning of huge political, constitutional, territorial changes in the Canadian Northwest. I'm not going to get into the details of that unless anybody has any questions later. But basically what had been Hudson's Bay territory, more or less under Hudson's Bay Company jurisdiction, now becomes a territory of this new country called Canada. The Dominion government of the day, the federal government, had full and plenary authority to legislate for this new territory, including administration of justice. The other thing that happens at the same time is the first province of Manitoba is created. And what I mean the first, I mean that first sort of square postage stamp size province that was created following the first Riel Rebellion in Manitoba in 1870. There's a lieutenant governor of Manitoba. By 1873, there's a lieutenant governor of the Northwest Territories. And in terms of administration of justice, the first thing those lieutenant governors do is they appoint the former Hudson's Bay Company officers as justices of the peace. Again, very limited powers. A lot of criminal and civil jurisdiction still remains with superior courts in Upper and Lower Canada. We don't see legislation for actual courts and judicial officers and those trappings until 1873, and some reorganization legislation that passes then. This is the first time that courts are created in the Northwest Territories by a purely Canadian authority, 1873. These courts are basically stipendiary magistrates courts. Again, they've got limited jurisdiction, but they still are what we would consider to be courts in the modern sense. We also see the first criminal procedure rules, although these are the only rules that are promulgated at this time. In 1873, for Canadian history buffs, also sees the creation in this same legislation of the Northwest Mounted Police. Interestingly, part of the duties of this new police force are to attend in uniform in every instance where these newly created courts are sitting. And indeed, this tradition survives to this day. I was on circuit many years ago with Judge DeWert in Johaven, and the RCMP court officer showed up in his uniform. And Justice DeWert was very quick to remind this officer of the 1873 legislation and the obligation in that legislation, and the fact that the RCMP had been dutifully fulfilling that obligation since 1873, and that he had better go home and get his red serge on, which he did. So you've got courts for the first time, but you don't really get much by way, much more than that. You don't get what we would consider superior courts. These are basically just stipendiary magistrates. The only real change in 1875, it's the NWT Lieutenant Governor who now has the power to appoint these stipendiary magistrates. And really the only notable thing about this court is that this is the court that tries and sentences Louis Riel in 1885. That was stipendiary magistrate Hugh Richardson, sitting with Justice of the Peace Henry Lejeune and a jury of 6, as the criminal rules in those days provided. Interestingly, there was an appeal from that to the Court of Appeal, which in those days, the Court of Appeal for Northwest Territories was the Manitoba's Queen's Bench. The next period, again, you know, this is all very sort of haphazard, reactive, not proactive. The first Supreme Court gets created in 1886. It's created, but it doesn't last very long. It's got a very, very short and undistinguished history. Really, the only notable thing about the legislation that creates this court is that for the very first time in the Northwest Territories, the reception date for law is as of July 15th, 1870. So the date of the admission of Rupert's Land and the Northwestern Territory into Confederation. That's a huge difference. And that alone greatly modernizes the machinery of justice up here, as well as the administration of that justice. We also, for the very first time, get the very first rules of court. I've got a copy of those rules of court. These were promulgated on January 28th, 1895. I don't know if you can see from the Zoom, but it's thin. Like compared to what we've got now, I mean, this is, maybe a quarter of an inch thick. When you look through the rules, both sort of what they cover and the substance of what they deal with, they don't look that different from modern rules of court, or indeed the rules we've got now. They deal with appeals, controverted municipal elections. This is obviously a growing need in a growing territory. Cases stated under Section 900 of the Criminal Code, appeals and cases, trials de novo. A huge chunk of rules dealing with rules and orders under the Winding Up Act. I don't know what was going on in 1895, but man, oh man, did they need a lot of rules to deal with winding up of companies. I never would have dealt with that, guessed that. Deals with proceedings before a judge, orders, admission of documents, register and file of proceedings, attendance and appearance of parties, service of summons and notices, computation of time, costs, general directions, and then you've got at the back a tariff of fees. Obviously quite a bit different than what we've got now. Just out of curiosity, to pick a random example, the fee on a special applications and motion to a judge in chambers, which can be increased at the discretion of the judge. There's 2 tariffs. $5 is the higher tariff and $3 is the higher tariff. So just to give you an example of what you could get for costs in 1895. So this doesn't last. It's very shortly lived. And again, the next big development doesn't occur because anyone wants to do anything about courts or law in the Northwest Territories. It happens because the provinces of Saskatchewan and Alberta are created in 1905. The NWT Supreme Court is disestablished, and we are back to a stipendiary magistrates court. With respect to the stipendiary magistrates court, I will anyone who's more interested in this, I will refer to Graham Price's LLM thesis, the stipendiary magistrates court in the Northwest Territories. Very, very well-researched and well-written history of that court. I think Graham might even be on the call today. So if you have any questions about that, you can actually, there he is, I see him putting up his hand. So if you have any questions about that court, ask Graham, not me, because everything I'm about to tell you is based on research that Graham has particularly done. This is a fascinating court in a lot of ways because it occurs in what we would consider to be, you know, the modern era, I guess, the beginning of the modern era, certainly the beginning of the 20th century. But we've moved away from a Supreme Court back to a stipendiary magistrates court. They can exercise the powers, authorities, and functions vested in the old Supreme Court judges. So they're at least equivalent to provincial Superior Court judges, but they're appointed at pleasure. They have no tenure. They didn't require legal qualifications. Some of them weren't lawyers. And to say the least, this court has a pretty checkered and undistinguished history. Graham goes into a lot more detail about various examples of that. I'm not going to go into that detail here. But there were, you know, serious institutional impediments and constraints on these stipendiary magistrates. They were not truly impartial. They were influenced very strongly by federal bureaucrats as well as the RCMP of the day. They were very closely identified with the RCMP. They did not enjoy judicial independence. They had no security of tenure. They could be, and some were removed at the whim of the executive. Others get promoted to senior civil service positions. Others are forced to retire. And they had no financial independence or security as judges either. They had no institutional autonomy. They had no judicial control over the administration of justice, how the courts worked. There was no registry. There were no court offices, no court rooms, no court staff, no administrative assistants. They sat ungowned behind an ordinary desk in a civil servant's office, and they had to do their own paperwork. Anybody who's read Graham's thesis or has talked to people like Mark DeWert, who still appear before this court, it just, you know, as Mark DeWert said, it just didn't do, Scott. Certainly by the mid-50s, Yellowknife in the Northwest Territories had grown into a jurisdiction that needed more than a stipendiary magistrates court. And you know, I don't want to speculate too much. I'll maybe look to Graham for that. Whatever the stipendiary magistrate court could have been, whatever promise there could have been in that kind of court, that wasn't realized. And as Mark explained to me, I mean, there really was a crying need for a proper superior court and the proper judicial machinery to go along with that court. And you know, that's obviously part of a very important part of the judicial tenure. So we don't get that until 1955. And that's really, I mean, the title of this presentation is 1670 and 1955. It obviously doesn't end there, but 1955 is really the era, the start of the era of the modern NWT court system. The legislation is passed in 1952, but typical for government and typical, consistent with the theme of this presentation, the first judge isn't appointed until 3 years later, until 1955, and that judge was John Sissons. In this reorganization, the stipendiary magistrates court become, the territorial court becomes the superior court for the Northwest Territories. The stipendiary magistrates court becomes the police magistrates court. And in 1971, it's renamed to what we know today, the Supreme Court of the Northwest Territories and the Territorial Court of the Northwest Territories, respectively. So John Sissons is the first judge. I think most, if not all, the people on this presentation here today know who John Sissons was. And, you know, he really sets the model for not only what that court becomes, but what that court could be. And, you know, I think and it's not because of the intentions of government, it's not because of what they did in the legislation, it's not because of what anybody in Ottawa or even a territorial legislature at the time had in mind. 1955 is when I think we can maybe say that we're no longer, the evolution of law and legal institutions up here is no longer reactive, it's proactive. And it's proactive because of John Sissons. And what John Sissons does is realizes that he's the first judge of this newly created judicial machinery, and he can pretty much do what he wants. And I don't mean go crazy, although some people certainly thought he did, but he doesn't feel constrained about doing things the way they do them down south. He is, for anybody who talked to anyone who appeared before him or traveled with him, or if you've ever read his autobiography, which I highly recommend, he was openly hostile to the quote unquote bright boys from Ottawa, who he constantly thought were interfering with his court and preventing him from administering the law the way that he saw fit. He sits on the Supreme Court for 10 years. He's followed by Mr. Justice William Morrow. Morrow had been a counsel, he's from Alberta, but he'd been a counsel who had appeared before Sissons many, many times. Obviously had great love and respect for the man. And when he's appointed to the bench, he really continues the Sissons model and approach. And I don't say that to suggest that William Morrow wasn't his own man. I never knew the man or met him, but what I've read about him certainly suggests that he was. But he doesn't fall back into old patterns. He very much feels that he can continue in what John Sissons started, and again, doesn't really feel constrained about the way things are done down south. In a couple of cases, the Paulette case and some others, his authority, his jurisdiction is openly challenged by Ottawa, and he, quite aggressively pushes back against that and ultimately prevails. Again, I'm not suggesting that William Morrow wasn't his own man, but you can't help but see a little bit of Sissons there. So those two, I think, they bring the court into the modern era. And I want to emphasize, it's not just the legislation, it's not just a change in a legal or a constitutional or a political reality. I think we were very, very lucky here in that our first real Supreme Court judges, if I can call them that, were those two, because they really did set a model for what was to come, and they really did prove that not only things are different up here, but that we can do things differently up here. We aren't shackled by the law in the same way that maybe colleagues and courts feel down south. And to use a very broad and generic term, the realities of the North require us to be more sensitive and to apply the law in different ways. The court does continue to evolve after 1955. Obviously, there are more judges now. I think, structurally, constitutionally, I think maybe the most important recent change was with the creation of the Nunavut Territory in 1999. There were options open for that new territory to replicate basically the same model that we had in the Northwest Territories or go a new way. Perhaps not surprisingly for the North, and in keeping with the theme of today's presentation, they decided to go a new way, and they decided to create the Nunavut Court of Justice, That's a fused bench. It combines a superior court with a territorial court into one. So there's another step in the next evolution up here. Are more changes possible? Absolutely. Are they probable? I don't know. If I'm feeling brave, I would say that I don't know that we're ever going to see the kind of fundamental legal and constitutional changes to the legal structure up here that we have in the past. But those courts are going to continue to evolve. Certainly, one of the biggest changes since I moved to the territories 30 years ago that I've seen is the conclusion of more comprehensive land claim agreements up here, and of late self-government agreements to go along with that. The Tlicho Agreement was the first self-government agreement in Northwest Territories. Delaney was the second. There will be more. And if you look in those land claim agreements and you look in those self-government agreements, there are new roles identified and new jurisdictions identified for the NWT Supreme Court. There is a concurrent jurisdiction for that court alongside the federal court. And I can tell you, having worked with the GNWT on the negotiation of the Tlicho Agreement, you can draw a direct line. You can connect the dots from John Sisson's to the Tlicho Agreement, because one of the reasons Aboriginal people in this territory, at least in my limited experience, are comfortable with giving the NWT Supreme Court concurrent jurisdiction over their agreement is because of people like John Sissons and William Morrow. There is a comfort with that court. There is a sense that that court is ours, or is more sensitive to us, or is more responsive to us. And I think you definitely see that reflected in those agreements. As I said at the beginning of this, I think one of the themes is that a lot of the evolution of the law and its institutions up here has been this absence of mind. There's never been any deliberate plan or design for administration of law up here or the development of legal institutions. But again, if I may be so bold, I will suggest that I think we have a better system for that, and one that's better suited to this territory and to the people up here. And I think those are differences that we can be proud of when we're talking to our southern counterparts. That's it for me. I've hopefully left some time for questions or discussions. At the end of my speaking notes, for those who have a copy or who get a copy, there's a bibliography of various sources that I've relied on to put this presentation together. If you're interested in this, please try to track those sources down. I can give you a hand doing that. I would very, very highly recommend that you read Sissons and Morrow's autobiographies. They're incredibly interesting. There are some, genuine laugh out loud moments in those. So give those a shot. And again, thank you very much all for coming.
Scott, we had a question. One of the question we had was, who was defined as an indigenous person or as an Indian under the 1670 Act, or was there a definition?
There was no definition, but if you give me a minute, I mean, that authority derives from the Hudson's Bay Company Charter of 1670. This is really sort of the beginning of the era of European colonialism in the New World, and there isn't a lot of no one cares about the Aboriginal people because you know, where the enlightened power from Europe come to, you know, claim the New World and save the Aboriginal people from themselves. The assumption in the charter is, well, yeah, there may be Aboriginal people there, but whatever, you've got authority over them. I'm just sort of trying to flip through here to find a particular reference. I can't as yet. But to be clear, I mean, there was no special regard given to Aboriginal people or anything like rights of Aboriginal people or how the company would have to deal with those people or not deal with those people, as the case may be. It's like, yeah, they're there. You can, you know, you've got all these, you're the only one who can trade with them and impose the law on them and, you know, basically do whatever you want. A lot was left up to the company's discretion. It really was. And the relationship between Hudson's Bay Company employees and Indigenous people of the day, that was really left up to Hudson's Bay Company policy. That wasn't a matter of law. And it certainly wasn't a matter of, you know, any sort of restriction that was imposed on them by the Crown.
Thanks, Scott. John Donaghy makes a comment. He says that the Mackenzie Valley land claims driven by Aboriginal negotiators forced the federal government to agree to exclusive jurisdiction for NWT Supreme Court in matters of judicial review for co-management boards.
Yeah, that's right. And I should have sort of added that as a part of the comment I made with respect to the land claims and the self-government agreements. But yes, that's absolutely right. And again, you've got the MVRMA is a federal statute. It creates a number of different boards, which under the Federal Court Act and rules are considered to be federal tribunals and would normally fall under the jurisdiction of that court. You know, however, in that act and in those claims, it's the NWT Supreme Court that's given a jurisdiction for those matters. And again, I think, at least partially for the reasons I suggested.
Any other questions of Scott? If not, I can see from the notes we're getting that there's a number of people who have asked for copies of your presentation. We have it, Scott, and if you are interested in getting it, can you send a note to Bob at communications@lawsociety.nt.ca, and we will make sure a copy of it gets back to you. Scott, there is one other question from Doug Ray. Given that English law as it existed in 1870 was introduced into the NWT that year, I'm not clear what is the relevance of English law as it might have been going all the way back to 1670. Can we just not look at the law as it was in 1870? Can you comment on that?
Sorry, I'm not sure that I understand the question. Are you saying that? Are you asking whether we can ignore? We just ignore the date of reception of English law in 1870, or?
I think the question is, should we just be going back to 1870? Why do we need to go back to 1670? Can we not just look at the English law as it was in 1870 and not go any further back?
Oh, well, maybe I didn't make this clear, but when the Hudson's Bay gets its authority in the 1670 charter, it becomes pretty clear that whatever law it applies or administers in this Rupert's land that it now has control over, it's got to be English law. It's got to be whatever English common law or statute law prevails at the time. The problem is that there's no, you know, usually when a colony or a sort of a dependent territory is set up by a crown or a controlling authority, they will determine what law applies in that colony and as of what date. So that's still in question at 1670, and it remains in question for about 50 or so years. And increasingly, they need to figure that out. And so the Imperial Parliament in London passes legislation which eventually clarifies which law applies where. And ultimately, the law that applies, and they decide this in 1821. So this just sort of adds to the mystery. So in 1821, they decide that English law as of 1670 applies in Rupert's Land and what is then known as the quote unquote Indian territories. So in 1821, they already decide that the law that's going to apply is already 50 years out of date. So that's a problem. And I'm not a constitutional expert or a data reception expert, but my understanding from the research that's been done is that gets to be the problem, is unless you have got the legislative machinery, the legislative competence to actually change that data reception, or either provide, as most modern jurisdictions have, is, well, we've got that data reception, but everything's basically been surpassed by statute law now. In 1670, Hudson's Bay didn't have the capacity to do that. The Dominion government didn't care to. We can only speculate why. It doesn't get straightened out until 1870. And that's the first time that, okay, so this territory is now part of the Dominion of Canada. It's subject to the full plenary legislative jurisdiction of the Dominion government, and they can decide what they want to do with respect to administration of law in this new territory. So that's when they decide that you can actually get courts and whatnot set up. We can make decisions about what law is going to apply. Before 1870, that doesn't really happen. But you need, just to sort of to modernize things and to, I guess, give the courts, in whatever form they are, access to a body of law to apply. You needed to sort of drag that forward from 1670. But as I say, that's not done for quite a while. I'm not sure if that answers the question, but.
Great, thanks, Scott. It doesn't appear that there are any more questions. So on behalf of the Law Society, thank you for doing this. As Scott knows, this session was actually oversubscribed such that we had to drag him back, and he's going to do it again in June. So if you didn't get enough of Scott, you can sign up again in June. We have spots open. We have recorded the session, and we will at some point get it up on our new YouTube site so you can watch it again and again to your heart's content. Thank you again, Scott.
Thanks. I can promise you that, I am going to do this again on June 2nd or more times if the Law Society wants. But it's not a sequel. You don't need to tune in again. You're not going to miss anything. There's no outtakes or clips or anything like that. So
Thanks, everyone. We'll be ending it now.
Thanks.